Now we have a reserve time, a new part of our this year Board of Governors meeting. Yeah, that's what I'm getting to. Getting right there. I hope he was public and commenting about my mic not being on. To member and public comments, or the members of the public and comment to come and comment on anything and everything they'd like to comment on. We have 30 minutes reserved. Each speaker will be limited to 3 minutes. And is there anyone? Mr. McPherson. And what was your name, sir? Mr. Watley, you'll be after Mr. McPherson. Thank you.
Thank you, President. Give me some sound here. Am I on? Yeah. Thank you, President Majumdar. I was not able to sign up because of the ferry schedule that's been changed due to construction. There's a difference between observing a meeting and attending and participating in a meeting. As most of you know, as a 40-year member of the WSBA, I have spent the last 20 of those years attending the vast majority of these meetings, both observing and participating. I'm now concerned that the ability to make a comment will be curtailed going forward. And I'd like a clarification of that, at least now or at some point in personal discussions with each of you. The reason being that if we limit our comments to this 3 minutes at the very beginning of a meeting, it doesn't allow the participants, if that's what you expect us to be, to actively exchange information and ideas about comments that have been made by the governors. That's one. Number two is that if you limit my comments or any other public or member comment to the beginning of a discussion on a particular topic, it forces us to spend our few minutes guessing where the potential conflicts or problems are going to come up during the discussions. And I strongly recommend that even if you want to limit the amount of time, particularly if you want to limit the amount of time, that you allow us to make our comments after the governors have at least been able to discuss the issue at least once, all governors. That will give us a chance to focus in on those particular areas where the governors seem to have some disagreement or might want to elicit comment from the public and members. The reason I keep saying it that way is because as a member of the bar, I would hope that you would pay at least particular attention to me. And as a person who's attended most of your meetings for the last 20 years, I may be able to give you some insight that might help you historically on where you're headed in the future based upon where you've been in the past. So with that in mind, I do have a number of comments I would like to make about the bylaws. But many of them seem somewhat uncontroversial. Several of them are extremely controversial. I've got 57 seconds left. I will tell you this, that I don't know if she's on the phone at the moment, but I know that Jean Cotton is going to be listening in, and she wrote to you a very extensive material about the bylaws. And she and I have discussed this many times, and I read that material in its draft form. I agree with virtually everything in there except one thing about the executive director, which I kind of would like to talk to you about. But in that vein, I would like better clarification on how comments are going to be obtained, both from our members, and from public who happen to come in, which I obviously rarely see. So with that in mind, in my last 18 seconds, I'll waive that time. So and I know most of you personally, and believe me, you will be approached by me about many topics. I don't need to be on screen for all of them. Thank you.
So, Mr. McPherson, just to clarify, you will get an opportunity to comment on each and every topic that is on the agenda. Well, after that, I'm not sure about. That we're still working on. Last year, I think we may have had too free-flowing of a wild melee. This year, we're trying this different thing. But I also heard feedback from you and Ms. Cotton about how it used to be more regular and more free. You could walk up behind the governors, tap them on the back when the room arrangement used to be in a different kind of place. And I'm kind of hoping people will be willing to do that, and governors may be willing to actually yield their time to members of the public and members of our association who have specific additional feedback, critical feedback needs to get in, and it might encourage a little more interpersonal dialogue. But we're trying this. This is an experiment, and we'll keep seeing how it goes, and if it's not working at all, we'll retool again at the next meeting. Mr. Watley, thank you.
Board of Governors, thank you for allowing me the opportunity to speak here. It's good to see all of you again. I hope all of you had a great 2019, and I'm looking forward to 2020. I would like to echo this gentleman's sentiment that public comment, not just from the membership's perspective, but from the public's perspective, that we were given an opportunity to speak at every actionable item, to be able to have our voices and our opinions to be able to be expressed so the governors can make informed rather than malformed decisions on the actionable items that affect the membership and also the public. So I will reserve my time to speak for the actionable items that I'm come here to advocate for, which is for the public position on things that affect the public greatly. So again, I'm only here to help encourage you. I'm here to help inspire you to be able to act on the best institutions to protect us, to be able to honor this great seal of Washington, to have diversity and inclusion of the public. And I know that we're going to do great things in this coming year. So thank you again.
Thank you. Please come forward. What was your name?
My name is Jennifer Ortega.
Thank you so much, Ms. Ortega.
Also, because I am not certain that I would have had the opportunity to comment later, if it wasn't clear from the agenda, I'd like to comment now. This was a letter included in the late materials, but I'd like to read portions of it out loud. This is from the LLT board, talking about the bylaw amendments. The Board of Governors, the BOG, approved the 2 community member seats and the LLT LPO seat in September 2016. These changes to the makeup of the BOG were approved by the Washington State Supreme Court, which soon after entered a supporting order. No steps have been taken to fill the 3 seats. The inclusion of 3 at-large members on the BOG was a direct response to the task force report and the board's 2015 governance report. At a minimum, the same effort and consideration should be made to explain the proposed elimination of said seats. The mission of the Washington State Bar Association is to serve the public and the members of the bar, to ensure the integrity of the legal profession, and to champion justice. Eliminating the community member seats and the designated LLT LPO seat does nothing to further the mission. Legal issues impacting our communities are very real. The way in which the law impacts the people is shaped by legal professionals and the justice system. Intentionally choosing to leave those who are directly impacted by the profession out of the conversation perpetuates injustice and increases mistrust in lawyers and the legal system. Washington State professional boards like the Medical Commission and the Dental Commission have public members. The Supreme Court also recognizes the importance of public members, which is demonstrated by the makeup of the court's own boards, ATJ Board, Practice of Law Board, Limited Practice Board, and MCLE Board. If the BOG wants to adopt a governance model that differs from best practices, it should, at a minimum, publicly provide justification eliminating the designated LLT LPO seat, but allowing them to run for election by all of the members is the functional equivalent of excluding them. LPOs and LLTs constitute a small fraction of the makeup of the general WSBA membership, and therefore cannot, at least not equitably, run against the lawyer members in individual districts. It is important to note the total number of active LPOs and LLTs combined comes close to the total number of active lawyers in some of the congressional districts. LPOs and LLTs are licensed legal professionals with diverse experiences and perspectives and should have actual representation in the governing body rather than be treated as passive recipients of decisions impacting them, their clients, and communities. The LLT board therefore urges the BOG to maintain the designated seats and take the necessary steps to ensure community members, LPOs, and LLTs are given a voice. Thank you.
Ms. Ortega, thank you. And I appreciate you coming, if you couldn't come later, to give those comments now. And I think that's just the gist of this 30-minute comment period. It's for anyone to bring up any matters or to comment on anything, whether they can make it at a later time when something's on the agenda or there's something that's not on the agenda at all. So I appreciate all the comments. Are there any other comments from Ms. Hawkins? You had a maybe on your... Thank you, Ms. Hawkins. Wonderful. Governor Stevens?
Yeah, I just wanted to also add regarding, what we've talked about in terms of people commenting. I would hope that all the governors understand that according to what the issue may be, in your authority as chair of the meeting, you may reopen for comments according to how controversial something is, how many people have shown up. I think common sense would say we are not going to be so rule-bound that, we cut off hearing from the members of the public and our members when it's a matter of great concern. And I think that's just a matter of good judgment.
Absolutely. If anything, I try to be as a pragmatist and not an ideologue.